All right, folks, welcome to another GAM law session here. Today we're going to be discussing whether or not the Trump raid warrant violates the Constitution, the Fourth Amendment specifically to the Constitution. We're going to try to keep it under 5 minutes, give you what you need to know. As you can see here up on the screen, we're going to look at the actual warrant itself. The affidavit has not been released yet, but the warrant itself has. Take a look at that. We're also going to take a look at the Fourth Amendment to the United States Constitution. It's right there. It's one paragraph. It's pretty easy. Folks, you will be doing me a great favor if you would subscribe. And if you like this, clip it, cut it. Sharing is caring. Share it with people. And let us know we're out there if you like this content, because it is hard to grow a channel. I have not done one of these in quite some time, and I'll be honest with you, I got a little bit upset. They pulled out, it's one of the last ones I did. I did one debunking the 187 minutes of the January 6th committee. I appealed it and they denied it. And anyway, just upset me it's upsetting to have your content pulled down, folks. And it's especially upsetting when they claim you violated a policy and then you clearly didn't violate the policy. And they basically go, yeah, we looked at it and we came to the same conclusion. They won't even tell you why or where. But without further ado, we're back. So we're going to go over the warrant. By the way, if you're interested in, I've already put it in the description. You can pull this document up yourself and take a look at it and read it if I don't go over things that you like. Now, folks, I am a Florida and Georgia lawyer. I've been practicing law for over 25 years. I'm licensed in Florida and in Georgia. In fact, I am licensed in the Southern District of Florida. I've practiced and I am practicing in this court today, so I'm very familiar with it, folks. And on GAM law, what we do is we break down the issues of the day through the lens of the law, the Constitution, and history. Without further ado, here it is, folks. The search and seizure warrant is a standard form document which all lawyers use. A lawyer can fill this out and present it to a judge. You can see here down in the bottom, highlighted there, it was signed by Judge Reinhardt. There you go. The Honorable Bruce Reinhardt, U.S. Magistrate Court Judge. He is not a district court judge, folks. He is below a district court judge. He does not have lifetime tenure like all other Article III judges. He is appointed and can be taken out at any time. No, let's take a look at the document. And folks, the attachment A to this is the actual warrant. It's perfectly legal to attach things to it. In fact, it is the normative practice. Here's the premises to be searched. It's 1100 South Ocean Boulevard, Palm Beach, Florida, 33480. In case you're wondering where Mar-a-Lago is, folks, now you know. There you go. All right, nobody really cares about that. And they might, particularly if it was a sensitive location, but that's not apparently the case here. Attachment B, property to be seized. This is the big portion. You go before a judge, you ask him or her to do something, folks. I can tell you right now, they're gonna scroll, they're gonna flip. They're gonna go right to this. This is what they want to see. This is what they care about. This is where you have to list the documents that you are looking for. And we got to back up. We got to go back to the Constitution, folks. We got to go all the way back across the pond, across the Atlantic Ocean to merry old England and understand why we have something called the Fourth Amendment. We talk a lot on GAM Law and GAMcast on the Great American Mail. By the way, if you want to follow us on Twitter or on Substack, we have a lot of content out there. I put a link tree in the descriptions. Spoiler alert for Twitter, it's at @mail_American. It's MAIL, MALE. Anyway, Fourth Amendment. Why did they have the Fourth Amendment? Well, King George, the pertinent king when we left, obviously, but it doesn't matter, any of the other kings, they were issuing what were called in the law general warrants. They would just say, yeah, you can have a general warrant against the Great American Mail. You can have a general warrant against Donald Trump. You can have a general warrant against this location. And the government official would show up with the warrant and said, what are you looking for? What do you do? Anything I want, right here, general warrant. And they decided when they formed the Constitution, a lot of what we have in the Bill of Rights are all a reaction to the terrible tyranny the king was doing. So you will see when we read this makes sense. Listen, think about just being able to search for anything and look at what they did, what they came up with. Here we go right here, all right? The right of the people to be secure in their persons, houses, papers, and effects. That means everywhere you go, your car, your home, wherever you are, against unreasonable searches and seizures. That's the key part, really. Unreasonable. Reasonable search and seizures are okay. Unreasonable. All right. Shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation. Folks, that's why they're asking for them to release the affidavit. There is an affidavit. They appear to have abided by that portion. And particularly describing, this is the key portion you want to pay attention to, particularly describing the place to be searched. That was done. We saw that. They gave the Mar-a-Lago address, and you'll even see I may go back in a second and show you a little more. They even gave you the description of it, so that's fine. And the persons or things to be seized. All right, now this is key. Things to be seized. You've got to be specific. Can't have a general warrant. Remember, we talked about that. Let's go back. Just so you understand, that was attachment A. This is the place to be sieged. That looks to be, it's got the address. They describe it. It has 58 bedrooms, 33 bathrooms, 17 extra seconds. They're fine. I got no problem with that. Nobody should. Attachment B. Let's see if they particularly described the things that they were going to get. Okay. All physical documents or records constituting evidence, contraband, fruits of crime, or other items illegal possessed in violation of 18 U.S.C. Sections 793, 20, 71, and 1519. Folks, 18 is the criminal code of the federal government. You start at Section 1, you go all the way. You go thousands of them in there. Not going to look these up. I know what they are. I've looked them up on my podcast, which we do daily, a live stream, and we do a podcast you can find either in the link tree description there. I'm not going to go into them because it doesn't matter. That is not a descriptor, right? You got to have what you're looking for. You can't just say anything relating to this crime. That would be a general warrant, okay? Now, so here we go. A, they got 4 categories here, A, B, C, D. Let's see if any of them are going to be specific enough, sufficient to satisfy our Fourth Amendment. Okay, any physical documents with classifications markings, along with any containers, boxes in which such documents are located, as well as other containers, boxes that are collectively stored or found together with the aforementioned documents and containers, boxes. Any physical documents with classification markings, not going to cut it. I'm surprised a judge would sign this. I really am. And folks, just so you understand how this works, I've done this many times. There's lots of ways you can happen. Typically, at this point, the judge would say, I'm not going to sign this. I'm not going to sign A. Now, they can do one or two things. Typically, they will ask you to resubmit it, okay? Retype it up, redo it. But it just depends on the judges. You know, I've been practicing a long time, 20-plus years ago. It would be very common for the judge to just strike through A and go, okay, let's take a look at B. And if any of them survive, I'll sign the thing. If they don't, I ain't signing it. Or the judge can perfectly legal to just go in there and say classification markings relating to nuclear codes, national security, submarine production, tank production. He or she could put anything they want in there, or they could ask you to redo it. But the A, not going to do it. All right, let's go to B. Information including communication in any form regarding the retrieval, storage, or transmission of national defense information or classified material. Not specific. And anybody with any sense can just see that. No, including in any form regarding retrieval, storage, transmission of national defense information. That's so broad you could drive a truck through it. So, not going to get there. They're either going to strike it, make you redo it, whatever. Any government and or presidential records created between January 20th, 2017 and January 20th, 2021. Now, folks, Trump was elected in November 2016, but he doesn't take office pursuant to the 12th Amendment until January 20th, 2017. Any government or presidential records created between January? Are you kidding me? Folks, this is laughable. That's not specific. That's crazy. Any government document created during the 4 years he's president? Does that sound like describing the place to be searched? Yes, they have. And the persons or things to be seized? No chance. No chance at all. No way. Let's see if they catch it with number 4. We'll see. Maybe they can save it. Any evidence of the knowing alteration, destruction, or concealment of any government or presidential records, that's just a repeat of C, or of any documents with classification markings. Folks, not going to cut it. There's nothing in here with sufficient specificity. The judge should not have signed this. If and when this case goes forward, this document should be found to be inappropriate, improper, and illegal. And in America, unlike in England, we do not allow the fruits of improper searches to be used. It's called the fruit of the poisonous tree doctrine. Any and all things seized will not be able to be used. But now you have it. We have looked at it. You see it. If you want to go check it out yourself, I put a description in there. You can pull this up. And just so you know, I'm not hiding the ball here. The remainder of the document that has been released is basically the receipt of documents that they got. This also is not sufficiently specific, but there's no thing in the Constitution about saying we'll give you a specific receipt of what we took. So, unfortunately, that would not violate the Fourth Amendment. Anyway, I hope you enjoyed this. Again, if you did, please subscribe, tell others, and look out for our hashtag GamLaw in here. And we're going to be back now that we're got our feet under us again. We'll be doing a lot more of these. So, I'll see you on the next one.